This is an outline of today's presentation on our Insurance Data Security Act that was adopted by our legislature earlier this year and signed into law by Governor McMaster in May. Purpose of today's session is to highlight the areas of the Act and our implementation of the Act and answer questions that you may have. I just told somebody, don't leave here today with an unanswered question. The answer may be, we'll get back to you, but don't leave with an unanswered question. We've received, obviously, a number of questions on implementation thus far, and so this program is developed around those questions. We'll continue to receive questions. We'll continue to answer them either with an FAQ or something else on our website. The main part of the presentation is going to be by Dan Marsh and Gwen McGriff. Dan is the person that has drawn the short straw and is our Chief Data Security Implementation person. There is a massive amount of information about data security and this act, and it's time to be in the weeds. It's since we're the first state to adopt this NAIC model, we're like that little barking dog that caught the car. Now we've got the car stopped. We've got it surrounded. So we almost know what to do with it, and we appreciate your help in going through this process. Since we're the first state to do it, what we do in South Carolina will be reviewed by other states, emulated by other states. So this is a joint effort. So we recognize that there's not a one-size-fits-all for this statute. Different companies, small and large, have different data needs, different data information that they gain. So we'll be fairly flexible on how all that's interpreted. We'll provide guidance in the form of interpretive bulletins, FAQs, and maybe an additional seminar if we need to. Because as we talk to the industry, as we go through the process ourselves, we see a lot of different questions that are arising. And our goal, obviously, at least by January the 1st, is to have most of those answered. So we have a suggestion or two. Spend time on your risk assessment. Each licensee's risk assessment will be key to defining the type of information security program that a licensee must develop to comply with the Act. That's going to be the first document that the Department of Insurance looks at upon a breach, upon an investigation. We're building a web page. Dana talked more about that later on. And I was supposed to be hitting these all along, but I'm going to say what I'm going to say. It doesn't matter what these slides are. So since we're the first state, we have had a number of suggestions from a lot of people in this room about how we can change the law. The law went through a 2-year process. NAIC model, it was vetted. Hundreds and hundreds of pages of testimony. We had hearings, we had meetings, and then October of last year, the NAIC adopted the model. South Carolina, being the leading state in a number of areas, was the first state to consider and pass the statute. I appreciate the cooperation with the industry of not attempting to amend the model to death. In the process, we've noted a scrivener's error has to do with exemptions. We'll address that. I'm glad this is being recorded because you still need to know that's the only thing that we're going to address in the upcoming legislative session. the model's the model. It's an NAIC model. We are not going to do anything to undermine what the NAIC has done. The industry has asked for a uniform model. This is it. The U.S. Treasury Department has commended the NAIC for developing the model, has encouraged every state to adopt the model or something extremely close to it. And if we don't within 5 years, the Treasury folks will be seeking federal legislation to do that. There's some federal legislation out there now that would preempt state regulation. So it's going to come down to whether you want the federal government or what you're used to for 150 years, state government regulating the business of insurance. Last week I was pleased to see an editorial from the Insurance Journal commending our state for adopting it, and they had great things to say. Honestly, we did not write that. Couldn't have written it any better, though, I'll tell you. So we'll proceed with our seminar this morning. Please ask any question at the appropriate time. Gwen and Dan will tell you when the appropriate time is as they go through their process. But this is a joint effort. I can't emphasize that enough. In the event of a breach at your company, and you let us know within 72 hours, we're going to be your best friend. We've seen breaches in other places. This Model Act came out of, quite honestly, several breaches in 2014, led by the Anthem breach of 78 million people in this country had their information compromised. So the NAIC put it in high gear at that point, and have had a lot of work in this area, and the model is the last piece of the work stream that we had to do. But during the Anthem breach, 7 states became lead states, and they worked with Anthem on a daily basis and initially an hourly basis to see what to do for Anthem and what to do for the consumers of this country. South Carolina will be no different. We will be partners of any company or any licensee that reports a breach. At that point, information to consumers and how to further protect consumers will be our main goal. So at this time, I'm going to turn it over to Dan and Gwen. Right after I tell you that there are snacks in the back of the room. It's our tradition. Gwen's responsible for them this morning. There's coffee, there's snacks. And I'm going to tell you Gwen's responsible for it. I had nothing to do with ordering up and providing something called skinny popcorn. That does not sound right to me, but it's back there, and help yourself. Dan, it's all yours.
Good morning, everybody. That was a better response than he got. Thank you. Just kidding. All right, so my name's Dan Morris. I'm the Deputy Director of our Licensing and CE Division, and as the Director alluded to, a few weeks ago, I guess I wasn't living right, and he assigned the project to me, so to oversee the implementation of this Act for 2019 and beyond, so we're all excited about that. Let's see. So we're going to start with an overview of the law. We realize that many elements of this law may be new to you. Some of you may already have a sophisticated information security program. So at times we're going to be kind of 30,000-foot level. Other times we'll be in the weeds, trying to direct your focus in certain areas. So we'll start off with the always popular legal disclaimer, and that we're not providing legal advice today. Like I said, we're going to try to direct your focus in certain areas, try to touch on some of the hot button issues that we've received a lot of questions on. But ultimately, at the end of the day, when it comes down to your risk assessment and the overall implementation of your information security program, it's going to be up to you to sit with your legal counsel your IT staff, and management to develop what's going to be appropriate for your organization. So with that said, we'll point out that the session is being video recorded. If you're in attendance today, you are eligible for 2 hours of CE, and we do intend to put a copy of this presentation on our website sometime later this week. All right, so kick it off with the purpose of the Act. The purpose and intent of the Act is to establish some principles-based standards for data security, and it's also going to require a prompt investigation and notification to the department within 72 hours of the determination of an occurrence of an event. And we'll get into that in a little more detail shortly. This does not create nor does it curtail private cause of action. I want to stress that piece. All right. So who does the law apply to? It applies to basically all of our licensees with a few limited exceptions. That's from the carriers down to the individual levels. A lot of individuals aren't aware of that, so I could use your assistance in helping find every last one of them if you could. But first off, the licensees, that definition is key. It's going to include anybody that is licensed, they're authorized to operate, or registered under the insurance laws of South Carolina. And that's extremely broad, and the law only gives us a few exceptions right out of the gate. Those exceptions are your out-of-state purchasing groups, out-of-state risk retention groups, and reinsurers. So if any of those entities, the purchasing groups, risk retention groups, reinsurers, if you're licensed, chartered, domiciled in another state besides South Carolina, you're not a part of this. Okay, now there are certain other exemptions available. I know a lot of people have questions about the exemptions. We'll touch on that here shortly because they're not exempted from the entire Act, as the Director mentioned. They're exempted from certain provisions of the Act. And we also have a note here that licensees at a later effective date, you're going to require your third-party service providers to bring them into the fold of an information security program. That's also generated a lot of buzz, a lot of questions on third-party service providers. So I'm going to do the mature thing and let Gwen handle that shortly. You're welcome. So we just provided the licensee definition. Like I said, key there, if you're licensed, authorized to operate, or registered under the laws of South Carolina, insurance laws of South Carolina. All right, so the next key definition is non-public information. And that really is a key definition because that's the point of this law. That's what this Act and your information security program are designed to protect. So what's defined as NPI is very important. You would think most of that's pretty intuitive, but it gives you about 3 different buckets of what's considered NPI, non-public information. And that first bucket of information you'll see up there doesn't really jump out at a lot of people. And that's because it's the business-related information. If your business-related information, whose unauthorized access to, or if you lose this information, if that would cause a material adverse impact to you, that's considered non-public information, and that's something that needs to be protected. And if you lose that information, that's going to trigger the prompt investigation and notification requirements. So a lot of people don't really see that one coming in the definition of non-public information. The other two are a little more straightforward. They're regarding consumers' information. So it's the second bucket is essentially any combination of elements that can be used to identify a consumer, be that a name plus social, name plus credit card numbers, driver's license numbers, anything like that can uniquely identify a consumer. And the third bucket there is just a wide array of health-related information, except for age or gender. Pretty much anything health-related is going to be considered non-public information. All right, the next one is the cybersecurity event. Okay, I'll do a little bit of reading to you, but it's an event resulting in unauthorized access to, disruption, or misuse of an information system or information stored on that information system. So it's the unauthorized access to, disruption, or misuse. So a few things there. That's pretty broad, but the law does establish a few safe harbors. So one, it does not include the loss of encrypted information if you don't also lose that encryption key. Okay, so encrypted information goes out the door, you still got the key, all is well. It does not trigger a cybersecurity event under this Act. Something you should probably look into, but does not actually define a cybersecurity event. Another safe harbor is where NPI has been accessed by an unauthorized person, but it wasn't used or released, and it was either returned or destroyed. So if you lost the information, somehow you got it back, and you're relatively certain that no one spread it out there to the greater masses, you're okay. Now, from a practical standpoint, in addition to these safe harbors, the law only involves electronic records. All right, so that's key. If you lost regular paper, that's not considered a cybersecurity event and doesn't fall within the confines of this act. And then we'd also like to point out that, the unauthorized access to or disruption, the disruption of an information system could occur from a number of benign causes, most notably a power outage. So we don't define that as a cybersecurity event. It's technically a disruption, but that's not something you need to report to us unless there's actually been, some unauthorized access or loss of some type of information. All right, so what constitutes an information security program? That basically means it's the safeguards that you have in place to protect NPI. The majority of this law is going to be surrounding an information security program. More on the exemptions later, because that's what you would be exempted from, is having an information security program. So I'll save that for a little bit later on the exemption talk. Turns out I'll save it for right now. So am I exempt under the Act? And if so, what am I exempt from? So we've got four main pieces here that provide an exemption. If you're a licensee with fewer than 10 employees, that's going to be key. If you're a licensee that's covered under the information security program of another licensee, you're exempt. And the third and fourth pieces here is if you get a HIPAA exemption or you're already compliant with the New York cybersecurity regulation. All right, let's see. Now again, that doesn't mean you're exempt from everything. What you're exempt from, I'm not going to read all these to you, we'll have this to digest later, but essentially you're exempt from Section 389920. Which is the information security program. That's the meat. That's where you're doing your risk assessment. It's based on the size and complexity of your organization. That's the safeguards you're going to have to put in place like we just discussed. Everybody, all licensees that this applies to, with or without an exemption, still have to do the prompt investigation, still need to notify the department within 72 hours of determination of a cybersecurity event. As far as the HIPAA and New York Cyber, if you plan to take advantage of one of those exemptions, you still have to do, again, prompt investigation, the notification requirements, and then you're also going to have to provide the department with an annual certification that you are HIPAA compliant or you're still meeting the requirements of the New York reg, plus a couple of other pieces of South Carolina's law, because we differ in a couple of respects as far as the notifications are from New York. And we'll issue our next bulletin. If you didn't see it on an earlier slide, the next bulletin will be on exemptions, followed by another on third-party service providers. So we'll provide some more detail on what exactly it is you need to fill out and provide a little more detail surrounding those four exemptions. Okay, so a number of questions we've gotten are around the New York cybersecurity reg. Why would we allow an exemption for that? And in a nutshell, side-by-side review, they're going to be pretty similar. And if you'd like to read more on it, please. See. Okay. So by now we've covered the licensees, the exceptions from that definition. Again, that's the out-of-state purchasing groups, risk retention groups, and reinsurers. And we've touched on the exemptions. Fewer than 10 employees, you're covered under another licensee's information security program. You're already HIPAA compliant and have that information security program in place, or the New York Cyber Reg. But the Act also doesn't apply to folks that don't have electronic information. If in that unlikely scenario, if you don't have electronic information, again, the Act doesn't apply to you if you haven't lost it. Licensees that do not have NPI, or those that only have the NPI of their parent. Okay? And again, assuming insurers, risk retention groups, and those purchasing groups in other states. I'll wait while y'all read that. Just kidding, guys. All right, so the point of this slide is to show, even if you're exempt from establishing an information security program under our law, you still have to protect information under various other laws. So we just provided that if you want to take a look at it. If you didn't know about these, now would be a good time to get familiar with them. Let's see. All right, some of the major components of the law, provided them here. I'm going to jump into them in more detail in the next couple of slides. And if you need me to circle back to anything, please feel free. So, what if I don't qualify for an exemption? What does the law require here? Well, first things first, you have to conduct a risk assessment. So again, this is no exemptions. You need to come up with an information security program if you don't already have one. First thing you need to do is conduct a risk assessment. That's going to be the process where you're identifying, analyzing, evaluating all the risks that your organization is facing and how you're going to put the safeguards in place for that. Then you're going to be required to develop, implement, and maintain an information security program. And number two, you'll need to designate someone on your staff who will be responsible for the information security program. And again, you're going to, at that point, you put the safeguards in place. That person's going to be responsible, along with board oversight, for determining and putting in place what's appropriate for the size and complexity of your business. You're also required under the law to train your employees and vendors and exercise due diligence in selecting the third-party service providers. Let's see. I guess I skipped a slide, but you can see here. For the reporting, I'll get into reporting in another section later. But internally, at least, there's some internal reports that you're going to need to provide to your board if you have one. And then there's some external reports that you'll need to provide to the department. By February 15th, 2020, this piece is for domestic insurers only, not all licensees. But by February 15th, 2020, you have to provide annual certification that you are meeting the minimum requirements of the information security program. So that's 3899.20. If you don't have an exemption, and this only applies to domestic insurers. Finally, as I mentioned, the board is going to be responsible for overseeing the development, implementation, and maintenance of the information security program. So board involvement is going to be key. Just a quick timeline on what's coming down the pike. January 1st, if you didn't know, the Act's going to be effective. What that means for you, you don't have to have everything in place on 1/1/19. The Act will be effective, but that does mean, with or without exemption, if there is a cybersecurity event, you do have to notify us within 72 hours. And again, more on that shortly. You have until July 1st, 2019 to have your information security program in place. So that's the next key compliance deadline. Again, February 15th, 2020, every domestic insurer is going to need to provide that annual certification going forward. And July 1st, 2020, you get an extra year to bring those third-party service providers into the fold as well. And as we wrap up this section of the presentation, we've included a couple of more slides here that if you're interested in looking at a little bit later, is just going through some of the data protection requirements that were already in effect prior to this Act. So again, this information should not be new to most organizations, but just in case it is, here are a few side-by-side slides so you can see kind of what else is going on in the industry. And with that, I'll turn it over to Gwen.
Good morning, everybody. Now, one of my challenges is going to be making sure that I know how to operate the the little puncher thing here. My name is Gwen McGriff, and one of my responsibilities at the department is basically dealing with compliance issues. Investigations falls under my area of responsibility. And so one of the things we wanted to talk about today is just about determining compliance with the South Carolina Insurance Data Security Act. Under the South Carolina Data Insurance Security Act, The director is given the authority to examine and investigate violations of the act. And this authority is in addition to any other authority that he has under Title 38. And basically, investigations will be conducted under this act and other general authority examinations as well. And so one of the things I wanted to talk about today, based upon the questions that we've been getting in, is, you know, what would we be looking for? This is less about investigations and examinations as kind of trying to give you some insight into what regulators may look for as you put together your information security programs. This is not like a gotcha moment or anything like that. It's just kind of taking you through the thought process of a regulator and hoping that this will help you figure out what type of documentation you need to have and what we're going to be focused on as we come in to do an investigation in particular, because examinations are conducted under Chapter 13. They will be in accordance with NAIC guidelines and any additional supplements that the NAIC puts in place for evaluating compliance with the law. And so I wanted to start on this slide first. So I wanted you to know that this is more about you achieving compliance and trying to help you achieve compliance with the Act. And so the tips that I have on this slide, I think are probably some of the most important. And if you take anything away from this, I hope you take away these tips. That is, be methodical in your approach to compliance. As you're going through and you're looking at the aspects of this law, make sure that you document your decisions about why you decided to do something, why you didn't. As you've already heard, assign responsibilities for your information security program to someone within your organization and hold that person accountable for it. This information security program or these requirements should be top-down, driven from the senior management of your organization, and not necessarily from the bottom up. Make sure you devote the necessary time and resources to your risk assessment. I cannot say that enough. Be sure you devote the necessary time and resources to your risk assessment. That's one of the first things you should do, and it's one of the most important things you can do. I think the director has already indicated that there is no cookie cutter approach to all of this. These programs are customized, and it's going to have to be based upon your risk assessment. The risk assessment is what's going to tell the regulator whether what you've done, what you have in place, is reasonable for your company. Develop a plan or a framework. I like checklists, but if you go out and you read, there's a whole bunch of stuff out there to read. If you go out there and you read it, they'll tell you to develop a framework, more than a checklist, but a framework and strategies for putting together your information security program. And from that, then you develop your policies, your standards, and your guidelines, and what should be included in that last bullet is train your employees and your third-party service providers. So we're going to just assume, for the sake of argument, that there's been an allegation that Harrison Insurance Agency has violated the law. And so, you know, that allegation will probably come in from an insurance agency right across the street, because they might think that Harrison is claiming an exemption that Harrison should not have, or something to that effect. There's some unfair advantage. That's typically how we get most of our complaints in. And so one of the things that we're going to look at as a straight out the bat is, does the Act even apply, you know, to Harrison Insurance Agency? Does he have any electronic information? Does he have an information system? And if he has an information system, does he collect NPI, non-public information? If he doesn't have an information system, then the Act probably doesn't apply, because the Act is designed to cover information systems. Now, I want to be clear. This Act may not apply to paper, to confidential information in paper format, but there are other acts that apply to it on a privacy basis. So you still need to know what those are so you protect that type of information. So the Act may not even apply. So that's one of the first things that we'll do. And then we'll look at, okay, does he collect NPI? And if he collects, and the answer to that is he has an information system and he collects NPI, then we're going to look, okay, Is there an IT management structure here in place? Who's in charge of the information assets of this particular company? And if there's a board, what role did the board or the senior management have in the governance and the IT strategies for this particular company? And if he doesn't, then we'll say, or if he doesn't collect NPI at all, then we're like, why not? Is he exempt for some reason? And if so, which exemption applies? The next part of our analysis, and the next thing that the director told you earlier, that we're going to want to see is the risk assessment report. We're going to want to know whether he has basically adequately assessed the risk of the company. The Act says that the information security program that you put in place has to be appropriate for the complexity and size of the organization. You won't know that until you do an assessment, a risk assessment. There are lots of issues or components to that risk assessment. You need to look at the data that you collect, whether there are different laws that govern that data. You need to classify that. We're not going to get into all of that today, but you need to do a risk assessment. See what look at your employees, what type of training you have, what type of policies. Basically look at those things to determine what you need, where your vulnerabilities are, and what you need to put in place to protect the confidentiality of the information that you have. Basically, from a regulatory perspective, what we will be looking at is we want to see, okay, your risk, told me you did a risk assessment. Is it documented? I want to see the actual report. And I'm going to be looking at that report to see whether or not you've been keeping it up over time, if you've documented it for changes that may have occurred to different software that you've added on, whether you're allowing for certain revisions of controls, and if you have, and if you're following it. It's one thing to have a risk assessment report, but you're not following it. Are you basically following the written policies and procedures that you have in place to protect the information, to protect your IT assets? We'll be looking to see whether the information security program is appropriate given the size and complexity of, of the licensee. Okay, Harrison Insurance Agency may not need to have the same information security program that a Harrelson Insurance Agency would have, just because of the sheer volume of clients, customers, etc., that Harrelson may have at her insurance agency. But these are the kinds of things that we would look at. These are the questions we would look at in trying to determine whether it's appropriate for the size and complexity of the licensee. An information security program, in order for it to be effective, you have to have policies in place that address technology, people, and process. And this slide basically illustrates under each one of those categories the types of policies and procedures you need to have in place to protect your information assets. And one thing I will highlight over and over again is that the weakest link in any organization are the people. You have to train your people. It doesn't matter what you put in place. If you're not training your people, you're setting yourself up. You have to train your people, and cyber attacks are getting more and more sophisticated. And so one of the things that we see is that they're not phishing right now. Used to be that the emails that you get, the little phishing attacks that would come in, you could look at it and say, oh, I know that's bogus, that's nothing. Well, they're going after senior members of organizations, and we call them whale attacks now because they're more sophisticated. They make it look like it's somebody that you know, somebody that you have had dealings with, and they're making it more difficult for you to recognize that it's a phishing campaign than they ever have before. So make sure that you're training your people and adopting employment practices and procedures to help create a culture of cybersecurity within your organization. So after you've gone through and you've put all these cyber policies in place, make sure that you go and you update your personnel policy manuals also to include and make sure everybody knows that it's their responsibility to protect the confidentiality of the information within their organization, that, that there's going to be disciplinary results or repercussions if they do not protect the security or confidentiality of information in the organization. At the department, employees have to, full-time and temporary, have to sign a confidentiality agreement when they come on board, and they have to agree to maintain the confidentiality of all information that they come into access with. As a part of their EPMS or their evaluation documents on there, they're rated on how well they protect the information that they come into contact with as a part of performing their daily job responsibilities. Not saying that that's what you should do. I'm just basically using that as an illustration. So, employees. And I told you that people are the weakest link in an organization. They continue to be. They have to be made aware of the security risks that are associated with their activities and what they're doing for your department. Training should be conducted periodically. So don't do a training 1 year and then 6 years later you're going to do another training. Come up with an interval or a schedule for doing your training. Make sure that the training that you conduct hits on the issues that were found in your risk assessment, so that if you know that people are sending information out via email, make sure that anything that they sell, that they're using encrypted email. Make sure that they're doing things to basically protect the information. Look at your risk assessment report, and those issues that are identified, make sure your training covers those issues. Risk mitigation policies and procedures. These are some of the most important processes and procedures that you can have in place. So if the allegation is that Harrison Insurance Agency has violated the act, then we're going to want to look at his risk management policies and procedures, especially if there's been some kind of incident or event. We're going to want to know what he put in place to protect his information assets. And it's easy to choose the right processes and procedures after a breach. You need to do that before the breach, and your risk assessment informs you or gives you the ability to know what you need to put in place and or not. And a comprehensive risk management and mitigation program is the only thing that stands between you and that hacker. It helps you stay one step ahead of a hacker or other cyber criminals, and enables you to resolve threats in your organization before they become a major problem. Now, the Ponemon, not to be confused with the Pokemon, but the Ponemon Institute, or the Ponemon Institute, or however they pronounce their name, they basically study data breaches and data security issues. And what they say, they analyze the cost, and they report that the biggest data breach cost drivers for a business involve employees clicking on links that they're not supposed to, failure to promptly investigate anomalies within a system. So if your system is slow, and you need to look into that, because it could mean that there is some intruder, some malware in your system that's lurking in there, that's not supposed to be there, and the other defenders and monitoring software is slowing it down to give you some kind of signal that something is wrong. So you need to look at that before it becomes a major issue. And then also failure to monitor system vulnerabilities and third-party service providers. So each of the questions on this slide basically are designed to get at what we consider to be some significant part of a robust risk management process. And that's a part of the analysis that we will look at to determine whether or not the risk management program is appropriate for the licensee. So Dan already indicated to you that effective July 1, 2020, that licensees have to have a third-party service provider program in place. Third-party service providers are one of the, like I said, people are the weakest link. They are in that people category, and they can subject your organization to liability. So we've received a number of questions from individuals about what a third-party service provider program should look like. And so we pulled out our crystal ball and started trying to put some things together to help you, hopefully, with that. Number one thing, you got to have a policy. You know, if you go online, you'll look, there'll be third-party service program policies out there. I think the FTC has a third-party service provider program. The FTC enforces Gramm-Leach-Bliley Act. You may even be able to find some guidance from the Office of Civil Rights under HHS with HIPAA, with the business associates. They probably have some guidelines out there as to what an effective program would look like, but what's your policy? You know, and also, again, your policy for your third-party service provider program needs to be based upon your risk assessment. And basically the bottom line in this area is, can that third party provide your data the same protection that you're required to provide? That's what you need to be assessing. And if they can't, then you need to look someplace else, or you know, or consider somebody else, because they're going to be subjecting you to liability. What your policy should address whatever your assessment. Do an assessment of your third-party service provider or whoever you're considering. Do that on the front end. We'll talk about that because that's a part of the due diligence part, the due diligence aspect of this. And think about the engagement. What are you hiring this person to, this third party to do? What type of data are they going to have access to? If there is a breach, who's going to be responsible for the cost of the investigation? All these things that you put down need to be reflected or considered and made a part of your contract on the front end. And so the due diligence piece of this basically means know who you're contracting with. You know, go out and do some investigation, look at them, make sure that they have the wherewithal to do what you need them to do, and that they are able to get insurance, cyber insurance, and if there's a breach or something on their systems involving your data, that they can indemnify you. There's no point in having an indemnification provision in a contract if they can't indemnify you. My grandmother used to say, you can't get blood out of a turnip. You know, she's like, go ahead, let them sue me. Can't get blood out of a turnip. So make sure they have the wherewithal to do what you need them to do. And as far as cyber insurance is concerned, they basically recommend that both the licensee and the third-party service provider have cyber insurance. And when you're doing your risk assessment, make sure that when you're looking at the third-party service provider, that there's not a gap between what that third party can do or the security measures that third party can do to protect your data and what you're required by law to provide. So, in summary, the documentation, the key documentation that we're going to be looking for as part of your information security program, they're listed here on this slide. These are all the different types of policies that they recommend for an information security program. They may be short, it depends upon the size and complexity of your business, or they may be long and very detailed, depending upon the size and complexity of your business. But this is the kind of documentation that we'll be asking Harrison Insurance Agency to provide to us. Now, the common information security program mistakes are not developing or failing to implement their policies and procedures. Or they may draft them and put them in a drawer somewhere. They don't implement them. They don't allocate sufficient resources to the continuous monitoring and updating of policies, the continued assessment of the threats to the organization, or they don't enforce them. Or they don't designate specific groups to maintain the program and hold those groups accountable. And they fail to effectively manage their third-party access to PII, NPI, PHI, or III. It just doesn't matter. They fail to basically monitor their third-party service providers. And finally, and not monitoring or appropriately training their employees. So if we send out interrogatories or a request for information as a part of an investigation, what we're probably going to be asking you for are the things that are listed on this particular slide here. And I said, there may be other issues. We're going to want your privacy policy. And privacy policy, that basically says how you treat the information that you get. You know, that basically goes to written and electronic information, but your risk assessment report, any other reports that you've done, if you had incidents and you've had someone come in and do a forensic investigation of your company, we're probably going to want to see some of those if it's something related. Your certifications of compliance, you know, cyber incident logs. We're going to want to see the documentation that you have in place. If the breach comes from a third-party service provider, we're going to want to look at your agreement, your policy, and what your program looks like as well in that particular regard. Now, all right, Harrison Insurance Agency has an information security program. He's subject to the act, and the next thing we're going to be looking at, he has a breach. A cybersecurity incident. So the next thing we're going to be looking at is his incident response plan. And what does he have in that incident response plan? Now, the incident response plan, in addition to the risk assessment plan, is a very, very important piece of, a very, very important document. Data breaches are very costly. The investigations can range into tens of millions of dollars, to just put it mildly. So the best way to lower the cost is by making sure that you have implemented an incident response plan, because this incident response plan is going to be your company's blueprint for how you manage a cybersecurity event. It helps you limit the damage. It helps increase the confidence of your policyholders or other investors if you have investors. And these plans help establish the roles and responsibilities of employees. They detail what the immediate remedial steps are going to be, and they lay out the investigation, communication, and notification steps that the company has to follow in the event of some type of cyber event. Now, I'll tell you, and this is, I guess, a personal story here. I was doing some work once at the department. And this has probably been within the last 3 years. And so, as a part of our incident response plan. And so, one of the things I was looking at, I was doing was with ethical walls, but I put in, you know, Chinese wall. You know, how do we, two lawyers in the office work on different things and not talk to each other? They talk about you putting up ethical walls. Well, I put in Chinese walls. And so, immediately, they sent out an alert to our IT people. Okay, and our information security officer. So I didn't even know that there was a problem. I printed the document off, and they came down to me probably about 15 minutes later and said, you were working on something involving Chinese walls? And I said, yes. And they're like, well, there was something attached to that. We've shut your system down. They took my hard drive. They took, I was out of work, at work, but I was without my computer, until they isolated my computer and made sure that there was no other issue. You know, that's a part of the incident response plan at the department. If you have a problem, if you have an issue, you're going to be out at least for 24 hours until our IT people make sure that your computer system does not pose any risk or threat, you know, to the rest of the department. But the cyber incident plans are very important because they help you mitigate damage and maybe liability to your company. Here are the various stages of incident response: verification, containment and mitigation, investigation and analysis, notification, and the post-response review process. The verification process is like you notice that the systems are going slowly and you're trying to see what's going on. Now, if you find out in this verification phase that, yeah, somebody did put some malware in your system, you don't know whether they've taken any data out, you don't know if they've looked at any data, you don't know any of that, but you know that there was unauthorized access to your system and that system had non-public information in it, how about give the director a call and let the director know that we know that if you put, we know that you're not going to have all the details. Dan will talk to you in a little bit about the notification form, and it recognizes that you may have to update that periodically. But we can work with you and trying to make sure that you manage this particular event. I can tell you that the time between actually, knowing that something's wrong, that somebody might be in your system, and figuring out whether that they took any data out, there could be weeks in between that. It could be a long period of time. So one of the biggest problems that I think, was it Verizon or one of the companies had last year, was that they delayed notification. They didn't tell anyone. And then when they really confirmed that it was a major issue, they had a public relations nightmare because everybody wanted to know, why did it take you so long to tell anyone? So let the director know, ahead of time, and we will work with you on that particular part. The notification that comes in the fourth little position there is really the notification to other regulators, to consumers, that kind of thing, and it will be triggered by language in the Act. When you're talking about the verification piece also, these are some of the issues that we're looking at, trying to figure out whether you've done these things there. Have you identified the systems that were affected? Did you contain it? Where did the risk come? Where did the incident come from? And it's going to take you time to figure out all of this, the answers to those particular questions. To the containment issue, get back to my own personal story where they took my hard drive away from me. We're going to be looking to see, what did you do to contain this, to make sure that there was no future or further damage to the system. Did you take the computers, did you lock the system down? Did you lock down your servers completely until you could isolate where this malware or this cyber event was triggered or initiated? Those are the kinds of questions or things we'll be looking to see whether you have contained or mitigated the damage from that particular threat. And was an investigation prompt? There are various reports out online, if you look, to see about the time when a company learns or suspects that something might be going on, and when they actively investigate. And your incident response plan is supposed to define what your investigative procedures are going to be. Make sure you're doing prompt investigations, because that's one of the things the regulators are going to ask you is, when did you first learn, that you had some malware on your system? Was that the first indication that you had that something was going on? And sometimes some of these hackers, they will put something in your system and they'll wait a year before they start extracting data. But there will be indications during that time that something's not quite right with your system. So make sure that you investigate so that you can basically get on top of it before it becomes a major issue. Once you know that there's an incident, get with your legal counsel so that you can talk about what the implications are of the cyber event. And notice I put cyber event there rather than cybersecurity event. Cybersecurity event probably has a definition similar to that of a breach, where notification, there will have to be notifications to consumers and to other groups. Not all cyber events are going to be cybersecurity events. Some of them you might find, like right now, there is a new phenomenon about cryptocurrency miners. Cryptocurrency miners are international actors that are basically putting information into various servers. They're trying to leverage servers of businesses across the world to basically mine for Bitcoin. And I'm trying to remember the Baker Hostetler. Baker Hostetler has done a report on the types of breaches and how these breaches are coming into play nowadays. And the cryptocurrency miner is one of the ones that they said that there is increased activity. They're trying to leverage systems out there to basically mine for Bitcoin. But talk to your lawyers. Have your lawyers basically review the laws to see what laws of your data is subject to if there is a breach, what the notice requirements are, and help you develop a notification plan. And when you start, and be careful with the cyber event, cybersecurity event language, because if you're sued later, it's going to be difficult trying to roll that back. Make sure that you're conducting your investigations through your lawyer so that there's privilege, there's some confidentiality associated with it. If you call something a cybersecurity event and it only turns out to be a cyber incident, you may have some issues walking that back later. But you need to get your lawyers involved early in the process. Here are the notification requirements under the statute for reinsurers. You'll see that in section 389940E. For others, 39-1-90 sets forth the notification requirements under the statute, and you'll see there that if there are the requirement for sending notice out to consumers is 1,000. If there are 1,000 consumers affected, you've got to notify the affected residents, the Department of Consumer Affairs, credit reporting agencies, and there's some language in there that makes it sound also that you might have to notify the Attorney General's office as well. For HIPAA, the threshold is 500, 60 days after discovery, and this slide basically highlights the type of information that needs to be in the letter. Gramm-Leach-Bliley, which deals with financial information like credit cards and PIN numbers, that kind of thing. They really don't have a specific notification requirement, even though they expect you to. But they tell you to take immediate action to secure information that's been compromised, to preserve relevant information, investigate how the breach occurred, hire a third-party forensic specialist in order to help you with that, and then to consider notifying consumers or businesses affected by the breach, credit bureaus, and law enforcement. Here are the costs of noncompliance. If Harrison Insurance Agency has a breach at his agency, and here are the potential, and we find that he's violated the act in some form or fashion. Here are the potential penalties that are associated with that. And the graphic there basically is an indication that in the first half of 2017, that there were 1.9 billion record breaches in the first half of 2017. In 2018, the Ponemon Institute basically has indicated, they average or they look at the cost of breaches across the country, and they're associated or affiliated with IBM. And so they study breaches. They basically indicated that the average cost of a breach, which it would include investigation and maybe some penalties in there, is $2.2 million for, businesses with fewer than 10,000 records, to $6.9 million for businesses with more than 50,000 records. And the mega breaches, which have 1 million records or more, they could go as high as $39.5 million. And know that these are globally. The cost of breaches in this country alone is much higher than that. And what they also report is that the cost of breaches could go down if companies did 3 things: encrypt data, monitor their third-party service providers and train employees, and use multi-factor authentication. Though they said it would go down exponentially if companies took that action. So I'm at the end of this segment of the presentation, and I'm going to end it the same way that I started it. Be methodical in your approach to compliance. Make sure you're assigning responsibilities for your information security person to people who are qualified to do so. Do not put your file clerk ahead of your IT program unless your file clerk has, hellacious IT qualifications, and they were basically just doing this until they got their SAN certification. Make sure that the people that you have in charge of your information security program know what they're doing. Devote the necessary time and resources to your risk assessment, and train your employees and your third-party service providers. That concludes this part of the presentation, and I think we can take maybe a 10-minute break for you guys to just stand up and walk around, and then Dan will come back and we will talk about the reporting requirements under the law. Thank you.
All right, folks, welcome back. I'm back again. Don't worry, we'll get through this together. We're almost through. We're going to hit some of the reporting obligations for what you're going to submit to your board if you have one. We'll go section by section through our reporting form in the event of a cybersecurity event, what you're going to tell us within 72 hours. We'll circle around to some FAQs, and then we'll open it up for some questions from everybody here. I'll just point out again, notice a lot of folks taking pictures and things like that of the slides that we are putting this out on our website, hopefully later this week. Shouldn't be a problem. And I'll get to the website in a minute, but it's going to be at doi.sc.gov/cyber. So if you go there, we'll have all things cyber related for this act, links to the bulletins, links so you can see PDFs of the forms, and eventually once the forms are up and live, you'll be able to click through there and get to and make a report. And Harrison Insurance Agency, I don't know if you were watching the last segment, but we're on to you. All right, gigs up. Pay attention. Just kidding. My wife told me this morning not to make any jokes today. So I'm going to go home and tell her I got one. It landed. She said, "You're not a comedian." I know, but Mason thinks I'm hilarious. She said, "Great. How many 4-year-olds are going to be in your audience today?" Have a good day. Love you too. Heading to work. So I got one. So, starting off with the annual report to your board. Again, if you have a board of directors. If you don't, this doesn't apply to you. Although it'd probably still be advisable to keep management abreast of what you're doing on this side of things. So what you're going to provide to your board of directors, you're going to give them an annual report. It needs to discuss, and this is required by the law, it needs to discuss the overall status of your information security program. It needs to talk about your compliance with this act. Where are the holes? What are the dangers here? What are you facing? And any other material matters related to your information security program. So I'll note the code section here. That's 389920. So if you qualify for an exemption, this is one of the provisions that will not apply. So again, if you qualify for an exemption, 389920 is the provision section that you're going to be exempt from. Let's see. So this is we've talked about this a couple of times, so I'll go ahead and beat the dead horse. On February 15th, starting 2020, if you are a domestic insurer, you will not believe how many producers have called me and asked about this particular report. This is for domestic insurers only. But February 15th, 2020, you will need to give us annual certification showing that you are meeting the minimum requirements of the information security program provisions. And we haven't developed a standardized reporting form yet for this. You don't need to have to worry about figuring out if you're going to send us an email or how you're going to get this information to you. We'll have a standardized form. We'll provide more additional guidance on that at a later date. Otherwise, from this slide, I will point out that you must maintain all records that support that certification for a period of 5 years for examination purposes. All right. So this is a screenshot of our website as it exists today. Again, doi.sc.gov/cyber. I can't say that, by the way, /cyber. If you go there, that's going to be our one-stop shop for where you can access the DOI's online services, which is the portal through which you'll make these reports should you have to. You can get copies of our forms, find any other information related to this act. So we'll put it all here. And as we get this webinar done, we'll put it out there. As we issue more bulletins, we'll put it out there as well. And we'll build out this webpage as we provide additional guidance and we receive more questions. We'll try to put the FAQs out there, things like that, good contact information. All right, so the biggie, again, the cybersecurity event notification. That applies to everyone that this act applies to, all of our licensees. Exemption or not, you still need to tell us after you've determined that there's a cybersecurity event, you need to tell us within 72 hours. Again, we'll walk through that form shortly. We're not going to ask you for every piece of information. As Gwen said, you're not going to know that stuff right away. That's just a matter of it. But what constitutes a cybersecurity event? What triggers this requirement for a notice? The key two different buckets here, but the key is if South Carolina is your home state or your domicile, you need to provide that notice no matter what, basically. If you've had a cybersecurity event, there is no minimum threshold for number of residents affected or anything like that. If we are your home state or your domicile and you have a cybersecurity event, that is the trigger. Now, if we're not your state of domicile, but again, you're a licensee, you're authorized to operate here, you're registered, you're licensed, the trigger is losing the MPI of over 250 South Carolina consumers. It's a two-part test. So if you lost the information of over 250 people, and you've triggered another law's notification requirements, or there's a reasonable likelihood of material harm to a South Carolina resident, or a material part of your operations. So again, 250 more consumers, and you've triggered another notification requirement under a separate law, or there's a chance of material harm to South Carolina residents or a material part of your operations. Note at the bottom, insurers must also notify the producer of record. That is one of the requirements of the law as well. Okay, so what information is required to be reported after the cybersecurity event? So we're going to walk through the form. Again, we realize you won't have everything that's on this form right away. So just like any other online form, the red boxes indicate the minimum required information. So you're going to submit the report within 72 hours, at least fill out the red boxes. And what's going to happen, you'll fill out this form, you'll submit it to us, you'll receive an automatic email back to you. It's going to have an event tracking number so that you can come back in at a later date once you've run your analysis, done the forensics. You can come back in and start to fill out more information that we've requested. So if you do this, you receive the automatic email. Please hang on to that event tracking number so you can get back in and modify your report at a later date. So Section 1, I'll point out in the header, we'll have a dedicated email address for all things for this act. It's datasecurity@doi.sc.gov. We'll encourage you later, if you have any other questions, you need additional guidance on something, if we can provide that guidance, just send your questions to that email address. That's datasecurity@doi.sc.gov. Otherwise, Section 1 is pretty simple. You're going to pick your license type, your company, an entity, an individual. You're going to need to put in whatever the identifying number for your company, your NPN, NAIC code, your new SBS number when you receive those. That'll fill in, that'll complete the name for you, and we'll just need you to add an email address. So the demographic information is pretty simple. So Section 2, we're requesting the dates surrounding this event. So the first one's the estimated occurrence of the event. If you don't know it, you can click off with the unknown box. That's not absolutely required, but if you know about when this event occurred, please put the date there. And the same goes for the estimated end. If you think you've already plugged the security hole, you think life is good, give us a date. If you don't know, you don't know. If it's still ongoing, just click off the unknown. And the other box that is required is the date you discovered the event. You do know that one, so just put that in and move on to Section 3. Section 3, we're just requiring, these are pretty general categories, but we just want you to check off what type of event applies in this situation, if it's phishing, unauthorized access, etc. Just fill out as best you can on this piece. We're going to be in contact with you pretty quickly afterwards. We'll be having constant contact, and we'll learn more about the situation as it progresses. But at least initially, just click off what you think the type of event it is. Section 4 is the circumstances surrounding the cybersecurity event. So how was the information lost? How did you discover it? Things of that nature. So, of course, this one's not red, therefore it's not indicated. We don't need that within 72 hours. It'd be nice if you knew. But as far as how your information, how does someone get into the system, obviously you may not know that within 72 hours. So this would be one of those important fields where we would like more details, most likely at a later date. Section 5, looking for details if there was a third-party service provider involved. That drop-down box there just asks you, is this, was this your information system? Was this the information system of a third-party service provider? If so, who are we talking about? What are their roles and responsibilities? Kind of what are they doing for you? What kind of information are they handling? So that's the information we're looking for in Section 5. Section 6, what type of information was involved here? Demographic, financial, health information. Again, check off all that applies as best as you can. And we also want to know in this section, what efforts are you taking to remediate the situation, to plug the gaps? Section 7, relatively straightforward. How many individuals or entities were affected? If you don't know, again, click unknown, but if you have a feel if it's 300 people, 3,000, 3 million, if you could venture a guess, we'd like to know, but if not, unknown. Section 8, again, if you think back to the definition of non-public information, one of those 3 buckets was the business-related information. If the loss of that info would cause a material adverse impact to your operations. Remember, business-related info would trigger NPI here. So in Section 8, if that's what you lost, we're looking for more details on what type of data, because that's pretty broad. What type of data was lost if it was business-related? Okay. Section 9, have you determined that this event has triggered any state or federal notification requirements? So again, Gwen touched on that there are a number of other laws that pertain to data security, be it paper or electronic. So if you've triggered one of those and you know it, we'd like more information on what you triggered, and if you have a copy of any kind of notices that have been sent out or that you're preparing to send out, we'd like you to attach a copy. All right. Section 10 is law enforcement. Obviously, if there's been a theft of some kind, you're likely to file a police report of some kind. If you've done that, or if you've notified any other regulatory or government agencies, we'd like to know about when, and if you have any attachments that you can give us, provide more information to that effect, we'd appreciate it. Again, not required within 72 hours, but let's see. And Section 11. So, surprise, I've gotten quite a few questions about this one. So we're looking here for the contact details for an authorized representative that's familiar with this event. So some folks have asked, does this need to be, our CRO? Does this need to be our Chief Information Security Officer? No. We realize that some of your folks, they've got their sleeves rolled up. They're trying to identify the problem. They're trying to stop it. That they're busy in the first 72 hours, and we understand that. We just need an authorized representative, somebody on your staff that you feel comfortable with us contacting after we receive this form, somebody that's familiar enough with the matter, that's not about to go on a 2-week vacation. If you could put their information there, that's who we're going to contact, at least at the outset, until some of your upper staff has a little more time to get a handle on the situation and they can talk to us a little bit later down the road. Okay. Told you we'd get through this together. Section 12 is the attachments. We are looking for some of the basic documents that you're required to have under the law. This will just keep us from having to come during this part of the investigation to come ask you for it later. Things like your internal review, what happened in this instance, your privacy policies, and an outline of the investigation that you're conducting around this event. That's we're going to have in Section 12. Section 13, of course, you attest that this was, you tried your best, this is the truth under penalty of death, and so on and so forth. All right, so start with frequently asked questions. Invite Gwen back up to knock those out, and then we'll open up the floor for Q&A.
As the director indicated at the beginning of the presentation, we got a number of questions in, and we tried questions and comments, and we tried to design the presentation so that it would address most of the questions that we received from our licensees and other interested parties. We did pick out a few that were not included in that in the presentation per se, because they didn't deal specifically with risk assessment or some other aspect of the presentation. And one of the questions we got was, is it the licensee's responsibility to determine what is necessary and appropriate relative to authorized individuals, that definition under section 3899.10? And the answer is, yeah. This is the licensee's responsibility. It's basically, who are you going to give authority? It's almost similar to the concept of lease privilege. Who are you going to give access to your information systems? A number of people want to know whether the risk assessment can be done in-house, or do you have to have a third-party service provider? And that no shouldn't be there in the front. The act's not prescriptive. You make a decision about who you want to do your risk assessment. It can be done in-house, if you think that you have the staff that's competent and qualified to do it, or you can secure a third party to do it. It's really up to the licensee to make that determination. I would just say, stress, make sure the people who are doing the risk assessment have the qualifications in the background, necessary to perform it. Should a licensee send supporting documentation along with a certification of compliance? They're talking about the certification of compliance for insurers that's due February 15th of 2020. No, it's going to be a standalone document, and basically, as we envision it right now, the insurers will have to check off what they've done, certify what they've completed based upon what's in the Act, and then they sign and attest to that. We're not anticipating at this time that additional documentation would have to be submitted. If we need additional documentation, I think we have the ability under the Act to request it at that time. Under section 3890-70A1, a licensee with fewer than 10 employees, including independent contractors, are exempt from data security requirement, ? Does this provision mean 10 employees in South Carolina or across the country? This means that, it's across the country. If they're your employees and they're spread out across the country, we don't think that they have to be geographically located in South Carolina in order, if they're a part of your company, in order to count toward that, that number 10. Do insurance companies licensed to do business in South Carolina but domiciled in other states need to comply with the Act? Yep. They satisfy the definition of a licensee. Unless they're acting as a purchasing group, a risk retention group, or assuming insurer, if they satisfy the definition of a licensee, then they're required to comply. What information will licensees be required to retain under 3899-20B4? How long must licensees retain that information? This is really about records retention and basically a retention schedule, and that's up to the licensee. I mean, you're going to need to define how long you want to retain certain information. Now, under South Carolina law, I think the statutes say that you have to keep a complete and accurate record of business done for 5 years. So beyond that 5-year period, what NPI, what information you want to keep, that's going to be up to you and how you define that in your retention policy or your retention schedules. And one thing that we did not cover in all of this is that information security has it's a life cycle, okay? It's when you collect the information, it's protecting that information when it comes in your door, protecting that information when it's in your system, and then at the end, when how long are you going to keep it? And then at the end, making sure that you're disposing of it properly, that you're shredding it or using some other secure method. You're wiping computer laptops, and you have people there that know how to properly wipe the hard drive of a laptops. There's a life cycle to information. This is a part of that life cycle to information. How long are you going to keep it? Are you going to be like the Department of Insurance years ago? We used to have policies going back to 1910, okay? Until archives called us and said, do you really have to keep this, like this? And we had to think about it, so, oh, well, that's when we were keeping, that's before the advent of, all this technology and all that kind of stuff. So we did have a copy of policies, at the department. We have since, I guess, progressed from that now. I tell people I came to the department not when they were using the punch cards in, the mainframe when you punch them, but shortly thereafter, when I came to the department, we did not have, we didn't have a network. I mean, we had that a room about this big full with computers when I came to the department. But this is about retention and how long you're going to retain the records. The longer that you retain them, if you don't need them, you might want to destroy them, because you just, if somebody gets in, they could get information that you no longer need or no longer have a business need for. This question it says, independent of the provisions that apply to producers as licensees, are licensed agents, producers considered to be third-party service providers for purposes of a licensee's obligation under this section? Stated another way, do licensed producers have dual obligations as licensees and as third-party service providers? Short answer is no. There may be some situations, but it's all going to depend upon what that independent agent or what that person is doing. But if you satisfy the definition of licensee and you're acting as an agent in this particular instance, I do not think that you have a dual obligation there. How will the information that is shared with other entities, states, regulatory agencies, and the NAIC under 3899-60 be secured, protected against potential cybersecurity breaches? I already told y'all that they came and took my computer, okay? So you should be confident that we're like you. We're trying to do everything that we can to protect the information that we have at the department. We are required by law to have an information security program, and that's not a new requirement for us. We've been down this road of information security formally, I think at least since it was after 2007, 2008 when we first started it, and since Director Farmer has come on board, we've only intensified our processes and requirements there. But yes, we're doing everything we can to make sure that any information that we get from you, be it through notices, these notifications of cybersecurity events, to the information that's on your license application, that we're doing our best to protect that information. Any questions for us that right now? And even if you don't have any right now, feel free to send them to datasecurity@doi.nc.gov. Frank.
Gwen, I understand the exemption for HIPAA and having to file that certification. If you're exempt as 10 or less, or less than 10, is there going to be a requirement to file a certification that you're exempt?
Right now, we're thinking not. Right now, we're thinking not. And the reason, well, let me say this. We're not thinking about requiring you to file anything with us. But if you're asserting an exemption, one thing that you need to make sure that you have is a file that has the qualifications for it. Because we could come by later if there's an investigation or something like that. We're going to want to see why you think you're exempt, and you're going to have to prove that to us at that particular point. But as for having you file something ahead of time, right now we're thinking we're still going through that particular process. But if I had to say today, it would probably be not.
For third-party service providers, if they have a breach but it does not involve your data, is that something that is still reportable under the Act?
I will look at it more closely, but if it doesn't involve your data, I would not think so. Just off the top of my head right now. We'll put that in, we'll give that some more thought and put that in our frequently asked questions document that we're trying to put together. I think that the obligation should come about if it involves your data. But if you find out later that it did involve your data, you need to let us know as fast as possible. Well, we're not trying to put any additional burdens or responsibilities on licensees, but we want to make sure that licensees take the actions that are necessary to protect the data that they collect, store, distribute, or share with third parties. Yes, sir.
Have y'all defined independent contractors for purposes of that exemption?
Pass.
Sorry, guys. I mean, that's,
Oh, yeah.
from the title insurance world with our attorneys and
Yeah.
their relationship with, abstractors or couriers, it's gonna be very important for us to know where that exemption is.
Yeah, and we totally agree with you. That's going to be very important for our licensees to know. We started down this road. One thing I can tell you is that there is no statute or anything in South Carolina that specifically defines independent contractors. Independent contractors, that language is a product of case law. And so I'm in the process now of trying to go through the case law to see if we can find a standard that will work for our industry. Because right now, independent contractors, I think under case law, you're an independent contractor if the party, the principal, does not have substantial control over the work that you do. And so we're trying to run that through, I guess, a lot of different tracks to make sure that we've adequately considered all the different licensee types, all the different functions that a third party could perform, on behalf of a licensee. So that question will probably be addressed in future FAQs, but we are working on that. Mark.
If there's a breach and we notify the department and then provide all the documentation, is that documentation subject to the confidentiality provisions under like the market conduct?
It will also, so I think it's subject to it under 389960, and probably if it's if we're doing an examination, it would be under the work papers. But under 389960, that information should be confidential.
That's right. It's confidential and privileged under 60. It's not subject to FOIA requests, subpoenas, can't be a part of any civil action. That's about it. But 389960 is the correct statute if you want to take a look.
All right, thanks.
Yes, sir.
So if we're claiming an exemption under HIPAA, the first time we would communicate that to the department would be in this certification that's required February of
2020, February 15th, 2020. We haven't made that form yet, but what I would envision would be that the domestic insured that wants to, well, that needs to file first off by 2020, that they're meeting the requirements of the information security program. We would also provide in that form another option where you can check off that you're HIPAA compliant or that you're compliant with the New York Cyber Reg. So we've still got some work to do on providing that form, and I would imagine that would be done by the time we do our next bulletin, which covers exemptions. So hopefully we'll have that a little closer to ready by then.
You mentioned in one of your slides about the producers potentially in the dual role between third-party service provider and producer type. Who decides what they are? So you don't kind of have, if the producer says, oh, I'm under them, and
Well, I
then
think
they say, well, I don't, we didn't
And
make
I think
that.
what the slide said is that in most instances, they would not be in a dual role. They'd be considered a producer if they satisfy as a licensee.
Okay,
There may be some rare situations, and I think that would be fact-specific and would be driven by the facts. And we'd have to look at it at that particular time. If you have somebody that's licensed as a producer, but they're not performing the services of a producer for you, they're basically acting as a TPA or some other third party for your business. I mean, we would have to look at the specific facts of that particular situation.
perfect, okay, thanks.
On the 72-hour requirement, so if you are claiming an exemption because of the New York security rule, we would still have to notify them. Do they notify you guys? Do they look through the, do they make an assessment that, well, maybe South Carolinians have been breached as well?
You have to notify us.
Oh, we still have to notify?
Yes.
Okay,
The
okay.
only thing that exemption does is exempt you from having to do another information security program.
I see.
Okay?
Right.
And if you're New York compliant and you're using you're saying, I don't have to do another information security program because we're compliant, we have a program that's compliant with New York. you still have to notify the director, and you have to, basically, with our act, there are specific requirements in there about the detail. We're expecting you to provide that detail also. Now, New York and South Carolina law, they're aligned, and they match up pretty well. Each require an investigation. Our law says prompt investigation, and basically details the type of information that you would be expected to provide. We're going to expect that. New York, you should not rely on anybody to make the notification for you. New York, other state regulators are not going to notify us.
Okay.
I mean, they're not. So the licensee, that's a responsibility of the licensee. The licensee needs to do that. Any additional questions?
All right. Well, good. Well, then we'll go ahead and wrap this thing up. So, again, if you didn't get
An exact answer to your question today, or if you think of other questions as you come back, please email us at datasecurity@doi.sc.gov. As Gwen mentioned, you know, this extends to all of our different license types. I've got 12 or 13 different categories that fall under my area, and that's not even including the carriers themselves. So what works for the title agents is not going to work for your bail bondsmen, is not going to work for your massive carriers. So there are things we need to be considering. Please do send them to us. You don't know what you don't know, so just make sure that we're getting as many answers to your questions as we can. Again, we're not providing legal advice. My lawyer told me to tell you that a couple of times. But yeah, do please send the questions to us. And otherwise, thank you very much for attending today.